Okay, we're going to go ahead and get started. Good afternoon, everyone. My name is Doug DiVirgilio. I'm a SCORE Minnesota mentor and a member of the Education Committee. And welcome to our webinar, Choosing the Right Business Type, which is a question I get all the time and is really something on the mind of most of our clients. Before I turn it over to Sara, some information about SCORE. I want to make sure you are all updated. So please do visit score.org/Minnesota. You can request a mentor there. I highly recommend that. You can see the profiles of our mentors, and you can see the recorded webinars and upcoming calendars. Now we have SCORE's been around for over 50 years, so is Minnesota SCORE. There are 10,000 volunteers nationally, 300 chapters. Here we have 90 volunteers, and they are from every background of business. Most retired executives that we can line up with you. You can choose them or line it up with what your specific need might be. So highly recommend that. How can we help you? Oh, let me go back. That's not the right slide. We can help in the pre-startup phase, research and planning. Lots to do if you're thinking about starting your own business, which many are. In the startup phase itself, another very challenging part of growing a business, especially a small business, which is our specialty. As you grow your business, there can be all kinds of challenges. And buying, selling, or closing a business. So just some ideas of how our mentors can help you and be a sounding board for you. And we have, again, tremendous resources, webinars like this, lots of online resources as well. So just some ideas of how we can help you. These are our sponsors. Without them, we would not be able to carry on. So we're very thankful for each one of them and what they do to help us provide what are free services to small businesses in our area and outside our area. So let me just give you an intro to Sara. Sara Castro Potts practices corporate business law, personal injury law, and civil litigation. She also practices product liability and mass tort law and has successfully represented numerous consumers against the manufacturers of defective and dangerous medical devices and pharmaceuticals. Sara is the former president of the Sarasota County Bar Association Young Lawyers Division, director and secretary of the Sarasota County Bar Association, as well as a current member of several other local organizations. Sara has experience in a wide range of cases, from multi-million-dollar merger and acquisition transactions to business finance transactions. She regularly counsels business clients across a broad range of matters to understand and minimize risk and liability while implementing effective business strategies and planning to maximize growth and potential. So with that, welcome, Sara. I will stop my screen share and turn it over to you and your slides.
Sounds great. Thank you, Doug. Is that visible?
Yes.
Okay. So I'll discuss a little bit about the things that you should consider when choosing between entities in Florida when you are looking to form a business or maybe take your sole proprietorship and go ahead and form an entity instead.
Sara, let me just share. I forgot to share with everybody that we would like you to put your Q&A in as you have them in the Q&A section there. And at the end, Sara will go through those. So please use the Q&A section for that. Also, each one of you will receive a recording of this webinar and you'll receive Sara's slides sometime today or tomorrow. Sorry, I forgot that. Sara, go ahead.
No worries. Thanks, Doug. So there's something to consider here that often gets confused, and I find a lot of clients asking questions about this. So there's two things to look at. There's the entity that you form when you file with the Florida Department of State, and then there's the tax election that you make for your entity. And so those are two different things. They sort of cross over in different ways, and we'll get into that. But what I'm discussing today are the entity types. And then for the entity types, with some of them, you have the choice of different tax elections. So what I do with my clients is I help them form the entity and I do all of the corporate side. And then I have them loop in their tax professional, so their CPA or accountant, to help them make the best determination as far as how they should be taxed. So you'll see a little bit more about that as we go forward. So these are the different entities that I'll go over. And then at the end, I'll summarize it. So it's a lot of information to take in, but the summary at the end kind of breaks it down and makes it a little easier for you to remember and understand. So sole proprietorship, this is something that is not separate from yourself. This is when you just go into business as yourself, you don't form an entity. There's no distinction between you and the business. The advantage is it's simple, but the disadvantage is that you are having no asset protection, no liability protection. You have no ability to be taxed in a different way. And you just are completely intermingling your personal and your business assets. So you have personal assets, you have personal liabilities, your mortgage, your credit card, and then you have business assets, equipment at the office, furniture, depending on what kind of business, inventory, things like that. And you have business liabilities and debt, so a business loan, things like that. When you do business as a sole proprietor, you intermingle all of that. So your business liabilities would be satisfied by income and assets from your personal liabilities would be satisfied by income and assets from your business, and vice versa. And you really don't want that, because if things are difficult on one side, you want to have that separation and protection for the other side. So it's simple, but it's not preferable. The next is the LLC, the limited liability company. This is a very popular option for good reason, as we will see. In Florida, for an LLC, you can choose how to be taxed. So you can be taxed as a partnership or flow through, which just goes through to your personal tax return. Or you can choose an S Corp method of taxation, or more unusually, a C Corp method of taxation. The LLC will protect your individual assets from your business liability, so it gives you corporate shield protection. There are situations in which the veil is pierced, and that's when you, among other situations, that's when you don't sort of maintain the required formalities of the corporation and you intermingle your personal and your business assets and liabilities anyways. As long as you follow the basic rules and maintain the formalities of the business, you get that corporate shield protection. You then also get protection of the business assets from your individual liabilities. So you get protection both ways. Also, your ownership in the company is protected from your individual liability. So not just the assets of the company, but your actual ownership of the company. So there are two different statuses for LLCs in Florida. There's multi-member and single member. If you have multiple owners, multiple members, you actually have better protection under the law. So this this evolved over time, but the current status is under the law that if a judgment creditor gets a judgment against you individually, they cannot take your ownership in the company of a multi-member LLC. The most they can do is put a charging lien on it and take any profits that you distribute to yourself. But if it's a small company and you are in control or in a good position with the other members, you can choose not to distribute profits and create a standoff. So that has some really good protection. A single member LLC still provides protection. The only difference is that if a judgment creditor of the owner is able to show that they won't have their judgment satisfied within a reasonable time, the court can order foreclosure of your ownership in the LLC. So you still get some protection, not as good as a multi-member. So for this reason, sometimes people will make a trusted family member a minority owner in the company to increase the protection level. So the formalities for an LLC are relatively easy to maintain. You're not required to hold regular or annual owner or manager meetings. So it's good to have some now and then. You might do it at least annually, but you're not required to. You're not going to be at risk of violating the corporate formalities by not doing that. You have to follow the formalities that I mentioned, but that's true for any entity. Separate bank accounts, title your assets in the name of the LLC, keep your funds and your property separate from your individual assets. And then you should follow the basic record keeping and other requirements in Chapter 605 of the Florida statutes. It seems overwhelming at first, but if you read through it, it's not too difficult. You should have an operating agreement. You should keep certain information either in a corporate book or electronically. As long as you do that, you're fine. The fees for this are not too bad. So this doesn't include attorney's fees, but the filing fees with the state are $125 to form it and $138.75 per year to keep it existing. So the fees are reasonable. And an LLC is going to be more marketable when you go to sell your business than a sole proprietorship, because you have everything in a corporate form and it's easily evaluated and more easily transferred than if you were to have everything intermingled with your personal assets. And for the same reason, it's also easier to obtain financing. So when you go to banks or other lenders looking for financing to expand your business, it's going to be much more easy if you have that corporate form. So that's a summary. So overall, LLCs are quite useful and helpful. Only downside, not as simple, but it's far outweighed by the benefits. The next entity is a corporation. So you have tax selection options there. You can choose to be taxed as an S Corp or a C Corp. A lot of small businesses will go with an LLC instead because they prefer the more simple method of passing through to their personal tax return. So again, that's a decision that you make with your tax professional, but you don't have that option with the corporation. You have the same protection of your individual assets from business liabilities with the corporation. You have protection of the business assets from your individual liabilities. But this differs from an LLC. So you actually don't have that same protection of your ownership interest in the company. So with a corporation, stock is actually considered intangible personal property subject to levy and execution. And so that's a whole lot of legalese. But what that means is stock is considered property that if you owe someone money and they use court process to come and take your property or your funds to satisfy what you owe them through the court system, they can take your stock because stock is considered personal property that is subject to that process, versus ownership interest in a LLC, as we discussed, is not subject to that same process in the same way. There's much more limitations on it. The corporate formalities are a little more than LLCs. You are required to hold annual director and shareholder meetings. The same other separation of assets and funds is required. And then again, there are record keeping requirements in different chapter 607 of the Florida statutes. It's relatively cost effective. The filing fee is $70 and the annual fee is $150. Also more marketable than a sole proprietorship and easier to obtain financing for the same reasons. So corporations are generally useful and of course better than a sole proprietorship. The only downside compared to an LLC is you don't have that protection for your ownership, your stock in the corporation. And the formalities are not quite as easy as an LLC to maintain. When I explain this to people, sometimes I get the question of, well, then why would somebody use a corporation instead of an LLC? Corporations may be more attractive sometimes to outside investors because of the additional required formalities. So investors might like that protection of having you being required to have annual meetings and things like that. So for certain businesses that look to expand significantly in the future or, go public in the future, that kind of thing, they might opt for a corporation. But for your normal small business, an LLC is very useful. General partnerships are the same thing as a sole proprietorship, but for more than one person. So when two people just start doing business together in their individuals' names, that's a general partnership. All the same downsides, no asset protection, you're completely individually liable for everything the business does. And then even worse than that, you're liable for everything your partner does. So you just really, really, really don't want to go into business as a general partnership. If you really want a partnership, there are other options where your liability is limited and it's really easy to transform it into that. So A limited partnership is similar to a general partnership, except that the limited partners get asset protection, but the general partners do not. They don't have any asset protection and any liability shield. So you also really don't want to do a limited partnership. There are better options with the same advantages, but not the same disadvantages. So it gets really confusing um, because there's an LP and an LLP and then a triple LP. But the limited liability partnership is basically like a general partnership, but with the liability protection. So they've created this by statute. And so in this type of entity, all partners share control over the decisions, but nobody has individual liabilities for the acts of the partnership. So it's useful in that you have that liability protection. You have a little bit less flexibility because basically all of the partners share control and can act for the entity, versus in a corporation or an LLC, you can elect who the manager is. You can choose who the manager is or who the president is, who controls it. And it doesn't necessarily have to be all of the owners like here. So it's preferable to a general partnership. It's basically the same thing, but with liability protection. And then there's the triple LP to make everything extra confusing. This one is like the limited partnership, but with the liability protection. So the general partners are the ones who control the entity and have decision-making power. The limited partners don't, but all of the partners, general and limited, have the asset protection, the liability protection. So this is more costly of an entity to file. It's $1,000 to file this, and the annual report is 500, so the maintenance is more expensive for upkeep. So it's preferable to a limited partnership if you want a partnership. So this is a summary of all of the entity types. This chart can help you remember, how to compare them, and I feel like it makes it a little less confusing. So you can see at the bottom here that all of the entities have tax election choices, just the corporation has fewer tax election choices than the other entities. As far as management complexity, the LLC is the simplest and it has the most flexibility. So there are two types of LLCs under Florida law. There are manager managed LLCs and member managed LLCs. Manager managed LLCs are more common, at least in my experience. For a manager managed LLC, the manager has authority to act on behalf of the company. The owners don't necessarily have to be the manager. They can choose who to make a manager. It can be one of the owners or it can be a non-owner. And then in a member managed LLC, the members have to agree and make decisions together. So the manager managed LLC form is flexible, and you can have all the owners be managers or just one of the owners or someone who's not even an owner in certain situations. So it has a lot of flexibility, and you have the ability to build protections in to the operating agreement for yourself. So for an LLC, you form the entity with the Department of State using articles of organization. A lot of people will do this themselves and they think, I'm good to go. I form my entity, it shows up on Sunbiz. That's great, fine. But what they don't know is they're missing the operating agreement. So the operating agreement is the private document that you don't file, but it's arguably the more important document in that it has more information in there. And in the operating agreement, you outline the rights between the different owners as to each other. So for an LLC, owners are called members. That's just the name that means member for LLC, means owner for LLC. So you can have rights as to each other, and then you can have rights as to creditors and outside third parties. So provisions like creditors can't come in and force you to make distributions, things like that. Protection if one of the members files bankruptcy. You can have things like rights of first refusal. So if one of you wants to sell your ownership, you have to offer it to the other person on the same terms first, things like that. What happens if someone passes away? Who can it pass to? Does the person who receives the ownership get voting rights as well, or do they just inherit the economic rights unless you agree to give them voting rights? So these things are all very useful in a small company where you're likely working with somebody that you like and you trust, and you don't necessarily want a stranger to step in and take their position and have that same relationship with you. With regards to a single member LLC, same deal with the manager issue. With a corporation, you're going to have officers and a board of directors. It can be made pretty simple. You can have just a few people filling all of those positions, serving multiple positions. But then again, you have to consider that you need to make sure you hold those annual meetings for everybody to make sure that you fulfill those formalities. With the partnerships, the only two that are recommended are the limited liability partnership and the limited liability limited partnership. In those, there's less flexibility as to how you structure management, because on the LLP, all partners participate, and then on the triple LP, the general partner participates. The triple LP is more expensive annually, and all of the other entities are much more reasonable to maintain as far as filing fees. And then finally, with regards to protection of liability, the ones that are the best here are the LLC and then the two partnerships, because in those situations, a creditor of the owner can only take profits distributed from the business. They can't take the business itself. On a corporation, they can take your stock, and in a single member LLC, they can take your ownership, your stock, which is called a membership interest for an LLC, if they show a court that otherwise their judgment won't be satisfied in a reasonable time. And these all provide the corporate veil protection for the owners as long as you follow the formalities. So it's a little bit confusing and it's a little bit difficult to think about, but the way to think about the liabilities that might arise. So say, God forbid that you're driving in a vehicle and you get in an accident and you're eventually held liable in some amount. Say that a judgment was entered in excess of the limits that you carry on your automobile liability insurance. So if you only carry 100,000 and there ends up being a judgment entered for 150,000, that 50,000, that's your personal liability. So whomever is trying to collect that is going to use the court process to look through your assets and what you own and see what they can take to satisfy that judgment. And if it's a corporation, they will see that you have shares in a corporation and they can take that. Now, a lot of people aren't going to want to take a closely held small corporation because they're not going to want to take over running it. A lot of times it doesn't have value without you running it. But it's still nice to know in a multi-member LLC that you don't even have to worry about that or get to that point. You have that protection. They can always take the profits that you distribute unless they're otherwise exempt. But you can, in a entity that is structured properly, you will have control over when distributions of profit are made, and you can create a standoff and choose not to distribute profit. So something that I wanted to add in today to consider, since this is a presentation on choosing an entity and the right choice for you, if anyone is going to go through this process, this is a new law that will be very relevant. So it's called the Corporate Transparency Act, and it creates some requirements that are actually very broad and very serious and very new. This just came into play this year in 2024. And even amongst attorneys, it's sort of surprising everybody how strict it is and how stringent it is and punitive it is if you don't follow its requirements. And it's really not something that everybody is going to know. And there are a lot of people out there who form their own entities and would not have any reason to really know this, because you don't receive a warning along the way, or any notices. That the Department of State doesn't tell you anything, because this is something that is at the federal level. So the Florida Department of State has no reason to let you know. So under the Corporate Transparency Act, if you form an entity and you are considered a reporting person, then you have to file something. So if you create the entity this year, you have to file it within 90 days of creation. If you created it before this year, everybody has to file by the end of this year, or January 1st, 2025, I believe. So there's going to be a mass amount of filings by the end of the year. And so what has to be disclosed is any individual who has either control or ownership in the company has to be disclosed. And so that could be somebody who actually isn't an owner, but is a senior officer and has influence over important decisions. They are going to have to report their information. So even sometimes general counsel, the attorney for the entity, will have to report their information. Anyone who owns at least 25% in the entity will have to report. Some people don't, like minors, but it's best to inquire if you think you might. So for owners, your full legal name, your date of birth, your current street address where you reside. A lot of people use a business address, but you're going to have to report your real residence, and an ID number. So your driver's license, your passport, and then you're going to have to provide a photo of that. And for companies, they are going to have to provide all their basic information too. And so this act is actually intended to sort of assist with discovering illegal activities and money laundering and things that are being done. So hence the name, the Corporate Transparency Act. So this is going to require a lot more reporting on who owns entities than has been done before. Before, you only had to file your tax returns, form the entity, but otherwise there were many ways that you could keep the ownership private. So these are the deadlines that I talked about. And this is what I mentioned about this being surprisingly punitive and strict, is the penalties for not reporting are going to be $500 a day, up to $10,000. And then also if someone commits a grievous failure, it can be up to 2 years in prison. So being an attorney and having a lot of clients who form their own entities, or, I advise them to seek professional assistance, but people still do it. And seeing people in these situations, I am very curious to see what will happen with these strict penalties, because I believe a lot of people will not be aware of this. Attorneys generally are, but I don't believe the general public is yet. And you can form an entity without an attorney. So this is something that really needs to be done with care. And this is what I was saying, consult a professional for assistance, because it can be complicated. If you have your trust owning the company, then you might have a different trustee of the trust than the owner of the trust, and everybody's going to have to be reported. So that's really something to think about and be aware of if you form it, because it may not be included. So if you hire an attorney to form your entity, this is not automatically included. This is something you actually have to ask for separately. It's a different and separate filing. So it's something you really want to keep an eye on. And here are just 5 basic tips. Since this is a webinar for people starting entities going into business. So we've been over 1, do not operate as a sole proprietor. Number 2, put agreements in writing. So a lot of people I find respond to me on this by saying, well, I trust the person. It's fine. We've known each other forever. Everything's going to be fine. It's not that big of a deal. The contract's not for that much. But the useful exercise about putting agreements in writing is that it actually helps weed out misunderstanding. So you might think you're on the same page, and you might both be going into it in good faith and, happy about where you are and thinking it's going to be great. And then when something happens, you'll realize that you thought that your rights and liabilities and obligations were different. Well, I thought you were going to do this if this happens. And I thought you were going to do that. And then the dispute happens when it's too late to talk about it. So it's not just a lack of trust for putting things in writing. It's also to maintain a good relationship and work out the details ahead of time. Putting pen to paper really helps you think about what might happen and with the assistance of a good attorney, they will say to you, what do you want to do in this situation, and go through a list of situations and help you agree on that ahead of time. And it's a lot easier to reach agreement when the thing hasn't happened yet, when you don't have the dispute yet, when it's ahead of time, and it really can help maintain a good relationship. So have your contracts reviewed. I would say contracts that you use on a repeat basis, definitely, or any contract for any large project. One thing to think about, having your contract reviewed isn't always to make sure you get paid. So say you perform a service for $500, you're not having that contract legally reviewed just to make sure that you can collect your $500. You are having it reviewed to make sure that you don't end up being liable for things that you don't want to be liable for in the performance of that contract. So even if it's only a $500 contract, if someone gets injured while the contract is being performed, or if there is property damage or allegations of work being done improperly and the cost to fix it is in excess of the contract amount, the liability can be hundreds of thousands or even more, no matter what the contract price is. So it's not about the contract price, it's about controlling your liability and minimizing your risk in the situation that you're in, and protecting your business. You should consider non-competes and also a non-solicitation and non-disclosure agreement for key employees or business owners. So this might be something you pop in your operating agreement if you have an LLC, or you can have it separately for, you usually don't do it for lower level employees, but for key employees who have access to important information that you have spent time and money to build. You want to protect that and keep the value of the business and the hard work that you've put in, so that somebody doesn't decide in a couple years, I think I can do this myself and then make all the money myself. I don't really need to be here. I've got good relationships with all of this business's clients. I'm just going to start my own business and take the clients with me. And then be wary when representing yourself in court. As a business, if you are in any other court than small claims, you are required to have an attorney. So in small claims, a business can represent itself, but if you have an entity and you show up to court in county court or civil court, which are the higher levels of court, then you are not even deemed to be there, because you can only appear through counsel as an entity. So be wary when you get served with a lawsuit, and be cautious about that. So that's it for the presentation. So I can take questions now.
Okay, we've got 7. Sarah, you can read them, or you want me to read them to you?
No, I got it. I found them.
Okay.
I wasn't sure if I could, but I did. Okay, so Lorenzo says, I am in Texas. Is this applicable to my business? So it honestly depends. My presentation is Florida law only and Florida entities only. So you should definitely consult with Texas counsel. But what I will say is a lot of the states base their law on a model LLC or other model corporation statutes. So there are a lot of similarities state to state, but there are very important differences, like the multi-member versus single member thing that I discussed, that developed in Florida through case law and through a statutory change. So it is Florida specific, but there are some important takeaways that you should use to go seek counsel in Texas. So let's see. Richard said, why would you use a corporation over an LLC? So I mentioned this briefly, but just to reiterate it, certain people will want to use a corporation because they have a very specific business plan where they are intending to look to outside investors in the future. So, private equity companies or other investors, or possibly going public at some point, those types of people will use a corporation. But at the small business level, even businesses will still get pretty large being LLCs. LLCs are perfectly acceptable. It's just that investors sometimes like the annual shareholders meeting or annual directors meeting and those kind of formalities for a corporation. The next question is, can you explain corporate veil protection for owners? So it's the way that I would explain this is you just picture it like, here's your business and here's your personal life, and imagine a veil in between them. And so if someone attacks your personal assets or attacks your corporate assets, this veil protects the other side. So business liabilities don't go through and take your personal assets and vice versa. And that's why it's called veil piercing. So if you are doing really bad things using your business and you are doing fraudulent acts and really egregious things, illegal things, the veil will be pierced. You'll be personally liable. You can only get that corporate shield protection when you do things the right way, you keep everything separate, and you don't do illegal acts. That's when you maintain that corporate shield protection. And Joanne Santos said, I received an email about this from the state of Florida. I'm not sure what she's referring to. Maybe the Corporate Transparency Act. So if Joanne wants to specify, I'll answer that, but I'm not sure at this point what the question is. Anonymous say, what's a good way to find an attorney that will meet your needs? I tried to hire an attorney before I was an attorney. I did hire attorneys before I was an attorney, and I know it's really hard. I know it's hard because a lot of times you talk to staff before you talk to the attorney. You don't talk to the attorney until you make an appointment and pay a consultation fee. And I know a lot of times you really don't want to go around paying, $400 or $500 just to see if you like someone. So it is difficult. I find that, I will try to give my legal assistant and my paralegal as much context as I can to pass along to people so they know what they're going to get when they book a consultation with me. So I'll say, this isn't something I do all the time, but I can assist you with it if you want. You might get a better value for money if you find an attorney who specializes in this. Or if I don't specialize in it, I refer out to other people. But I would say call, ask the person who you speak with what the attorney practices. Ask them if what you need is something within their realm of practice. And also I would check reviews. Reviews aren't always accurate, but they are helpful. It gives you an idea, and attorneys aren't allowed to get fake reviews. I'm not saying none do, but they might, but that would be a serious license violation. So unlike some businesses where you can buy reviews, attorneys aren't allowed. We could lose our license if we got fake reviews. So check reviews. AVO and the Florida bar are helpful. And anyone can contact my office, and I have a good referral network for different practice areas. I usually have someone that I'm comfortable with takes good care of clients. If you have an issue, I'll give you a name, someone who practices what you need. Richard Siegel says, what do you charge to set up an LLC? It varies depending on the person's business and what I perceive to be their needs upon intake. So how complex it is. The cheapest one is $950 for attorney's fees, but it does go upwards depending upon what type of complexity they will need in the operating agreement. But with that said, a lot of people do just need the basic LLC. So, are there any books or similar resources you would recommend for someone starting a business for the first time? When I started my business in 2021, I read a few law specific books that were super helpful to me. So I don't know about general business. I mean, I know SCORE is an awesome organization for this, and you all are doing the right thing already if you're at SCORE. But this is a little bit odd. I actually found a lot of help in different Facebook groups. So I know that sounds really informal, but for example, there are Facebook groups out there for, attorneys doing flat fees or different groups. And I have gone into those groups and said, anyone starting a solo practice, can you recommend a book? And I've received book recommendations that way. So if you get the right type of group with, you know, professional people or people who are kind and helpful, you can, I found some really good recommendations there. Um, I do free consultations on certain matters. So for the personal injury and the defective medical devices and pharmaceuticals, I do free consultations. Um, I used to give free consultations on everything, but I found myself taking a huge chunk of time every day to do that and not having enough time to do my actual work. So I don't do it on other things anymore. But sometimes if someone is referred to me by someone I know or by SCORE or something like that, I'll take a few minutes and chat with them informally. Does it matter which Florida county you hire a lawyer to handle real estate matters? It doesn't. If someone has the license to deal, like it's either a title agent license to deal with real estate matters or practices real estate law county to county, you can hire them in any county. With that said, if they are located in or near the county where you are wanting to purchase real estate or deal with real estate, they'll have a better idea of the local procedures with the both the court and the official recording and things like that that can be helpful. Let's see. Oh, okay. So Joanne clarified that it wasn't a question. She's just saying she did receive an email about filling out the forms about the Corporate Transparency Act. So that's great that they are letting people know. I'm pleased about that. And somebody said, if I'm starting a 501c3, is it possible to find an attorney to set it up pro bono? How to find this attorney? You know, I don't know. I do charge for my 501c3s just for the reason that I explained before. You know, I have a small practice at this point. I don't have a lot of lawyers, and if I'm not working, I'd rather be with my daughter, my little girl. But there might be attorneys that set them up pro bono. Most of the pro bono work that I'm aware of is with legal aid, and they are usually focused on things like foreclosures and evictions as sort of a first priority. But you might have luck if you call the Florida bar, but I don't know of one off the top of my head. But thank you for letting me be here. It's been a pleasure. And if anyone thinks of questions later on, feel free to email me. I don't mind.
Well, we actually have a couple in chat.
Oh,
Um,
okay.
can you get to those?
Yep.
Okay, we have a few in there.
Okay. Let's see. Yeah, so Dawn is bringing up the issue of if you live in a house and then you move out and you want to rent it out, saying basically that the mortgage company would not want you to put that in an LLC. So how do you handle that? And that's true. That's called there are usually what we call a due on sale clause. So the mortgage company, if you try to transfer the property without their consent, can call the entire mortgage due. Well, the thing is, a lot of properties that get put in LLCs have mortgages with that clause on, but the mortgagee doesn't necessarily invoke the clause. So it's a risk that you should be aware of, and that could happen. But I have seen many people place their property into LLCs for asset protection with mortgages and not have that. I haven't seen a mortgage company invoke that clause. I mean, I actually have rental property in an LLC with a mortgage, and it was transferred with the mortgage, and that was not invoked. So I think mortgage companies can, but they don't always do that. And then the rest of the question. The rest of the question I think is negated by my answer to the first question. It's very common to just have rental property in an LLC, and then any liability arising out of that is only going to hit the LLC, not your personal assets. And let's see. So someone was asking about whether a corporation and an S corp is the same. It kind of is. An S corp is it refers to the entity, but it's also the way that it's taxed. It's the tax selection. So a corporation can be taxed as an S corp or a C corp. An LLC can be taxed as an S corp or a C corp or a partnership. So an S corp is how you're taxed, and the corporation is the entity form that you make with the Department of State. And then let's see. Yeah, this is about mail from the Department of State requesting that you pay certain fees or filing deadlines. There's a lot of junk mail and spam that comes in the mail when you form an entity, where they try to make you pay and try to make you think you need something. I can't provide any clear markers for you to tell, but the only thing that you need with your entities to pay is your annual filing fee, which I think is due about May 1st. And if you let it go invalid, there's a $400 late fee. But apart from that, you shouldn't have any fees happening. All of these things telling you that you need a certificate of standing, all of that's optional. You don't need that. If in doubt, call Sunbiz. Yeah. And I think I got all the questions in chat.
You did. Well, Sarah, great job. Thank you so much for presenting today, and thanks everyone for participating. You will again get a recording of this sent to you and the slides that Sarah presented. So we would also ask you to complete the survey, and I think she did a great job. So you'll get a chance to give us your ratings. We also want to know what other topics you would be interested in. So please let us know that, and refer Minnesota Score to those who may benefit from our programs. I think we have a couple more in chat that have popped in. Let me just check those. I think just thanks.
I think they're just thank yous.
Thank yous. Okay, we're good there. And that concludes our presentation for today. Thank you, Sarah, and thank you, everyone.
Thanks, everyone. Bye.